When can someone else bring a claim on behalf of another person?
It's a lot of work being a litigation friend, and it's a lot of responsibility.
Any resolution of a claim has to be approved by the court.
Usually most people realise that they would be better off having a professional deputy appointed.
But what about cases where the patient has died? Again, those pose different challenges.
It's not unusual for there to be differences and fallings out between family members.
It's helping them to make the right decisions, not imposing decisions upon them. Hello, and welcome to today's episode of Medical Negligence Matters. Today we're going to be talking about how one goes about bringing a claim on behalf of somebody else. And this raises a number of different questions. And with me to talk about that today is Tami Frankel. Hello, Tami.
Hi.
So, starting out, when can someone else bring a claim on behalf of another person? Well, I suppose the obvious thing is where the person who is injured is somebody who lacks a legal capacity. So that means somebody who is under the age of 18, or somebody who, for example, has a brain injury which prevents them managing
being
day-to-day
able
life.
to understand the process and give proper instruction.
And how is that different from a normal claim on behalf of an able-bodied person?
I suppose the main difference is the obvious difference in that you're taking instructions from and giving advice to someone who is not the person who's been injured. It's usually someone who's very close to them, such as a parent or a spouse, but it's not the actual injured person. And so what that person is doing is the best they can for the other person.
Yes, I suppose that's right. They're acting as a representative. And I suppose the legal term for it is a litigation friend, isn't it?
Yeah.
Somebody who lacks capacity to bring a claim on their own behalf has to have a litigation friend to bring that claim for them. And that litigation friend has to be an adult who has no interest that conflicts with the individual, isn't it?
Yeah.
And has the capability of, as you say, giving instructions on that person's behalf and acting in that individual's best interests. Say normally a parent or a spouse or a very close relative. Sometimes a friend, although that's less
fairly
common.
rare, yeah.
And I suppose it's somebody who is willing to take on the responsibility.
It's a lot of work being a litigation friend, and it's a lot of responsibility. Yeah, no, it's a lot of work. It's a big ask, but I think that's why it's always people who are close to them, because it's someone who cares enough to want to be sure that that person gets the compensation they need to ensure that they're looked after properly. Usually the litigation friend just wants the person to be looked after properly.
And how does the process differ? Well, not much.
Yeah, I mean, it's in terms of what we have to get by way of evidence, what we have to prove, it's the same. It's the same. It's really just the extra layer of dealing with a litigation friend rather than the injured person. And I suppose one thing you can't take into account is things that might be very individual to the injured person. You might not know those. And because you're acting in the best interests of someone rather than what they want to do, it sometimes means that you don't have options that you might with a non-injured person. I'm specifically thinking of the difference between somebody who may want to accept a settlement, which we may say is not, that they would be likely to get more, but they would like to accept it for reasons personal to them, such as they want to see an end to the litigation, they want to move on, they want to move away, they want to do things. That's not possible for someone who has to have a litigation friend.
I think that's right. And I suppose that I think for many parents or relatives of injured people are sort of slightly worried about taking on that responsibility and having to make decisions. But I suppose one reassuring thing is to know that the court always has oversight of
Absolutely.
Claims on behalf of children and people who lack mental capacity, because they have to take on that role of ensuring that the decisions that are being made on behalf of those patients and children are the correct decisions to be made.
In their best interests.
And I suppose as a lawyer, it doesn't happen very often, but very occasionally you can come across situations where one might be concerned that the litigation friend isn't necessarily making the best decisions.
Yeah. And that's not always because their heart isn't in the right place. It might be for all sorts of reasons why you just feel there's a bit of a conflict there.
Yes. And I think that it, particularly for parents of injured children, it can begin to feel a little bit like there's too many other people becoming involved in their child's life.
Yeah.
And I think that is a difficult thing for many parents to accept, because of course a seriously injured child needs a lot of care and assistance far beyond what parents would normally be expected to give to healthy children. And I think it can be difficult for some parents to come to terms with the fact that they need to let go of some of those tasks and responsibilities.
Definitely. They sometimes feel, I think, that their rights as a parent, their choices as a parent are being usurped and that nobody's listening to them. And especially if they have been managing for the first, 5, 6, 7, 10 years of a child's life, it seems to them a bit much to suddenly have to lose a lot of that control and choice.
Yes, I think suddenly having what they see as a team of other people making decisions for their child or for their family member can be quite difficult. And I think an important part of our job is to help families to navigate that huge change in day-to-day life. And I think one of the benefits of being a specialist and dealing with these cases a lot is you become used to dealing with that sort of situation and giving people the best help that you can.
And explaining to them as well. I think sometimes the parents can feel just overrun with people coming and telling them things. But I think if you talk to somebody and explain to them what's going to happen and why, and where they do have choices, because of course they can make decisions for their children still, it just helps to reassure them a bit more and they can feel more at ease about what's happening.
That's right. It's helping them to make the right decisions, not imposing decisions upon them. But it's quite a tricky path to navigate sometimes.
They've also got often other children, so they might not want something that's been suggested because of how it will affect the rest of the family or other children. For instance, when they're looking at if they're going to be purchasing a property which is to be adapted, they might have a specific geographical area that they're not prepared to move out of, both because of, for instance, the school that the injured child attends, but also because their other kids may be happily settled in a school and they don't want to move that.
Exactly. There's a whole family to think about, not just one individual. And the claims process is really largely the same, isn't it? If the injured person is either a child or someone who lacks mental capacity. But the key difference is that when it comes to the end of a case, isn't it, that any resolution of a claim has to be approved by the court. And I think that parents and family members, I hope, can take some comfort from the fact that ultimately it's a judge who's very experienced is making a decision as to whether or not an agreement that's been reached on behalf of that injured person is the right decision.
Yeah, absolutely. And that's one way of explaining it to parents, is that there's an extra layer to ensure that the settlement is fair. Because, of course, somebody who does have capacity can accept a settlement which might be seen as unfair or too little if it suits them for various other reasons. But in the case of a head injured person or someone without capacity, they can't do that. The court has to approve the settlement and be sure that it is in their best interests.
And thinking beyond the settlement of the claim, the other key difference, I guess, is that somebody who lacks capacity, either because they're under 18 or because they have some mental disability or for example, a head injury or some genetic disability, then the decisions about how the compensation is dealt with, again, have to be overseen by the court. So for the sake, in the case of children, for example, the money is invested in court and remains there until the child is 18.
Yes.
Isn't that right? And with people who lack mental capacity but are adults, then the court of protection.
Yes, or of course children who will never gain capacity. Yes, it's kept in the court of protection. And those people will usually have a deputy appointed, which is someone who is appointed by the court to help to look after their money and ensure it is properly spent. And that person, the deputy, has to account every year to the court for what it's spent, what it's been spent on, and has to ensure that the money lasts for however long it's supposed to last that person. And
the deputy could be a parent, or it could be a professional, an individual, a lawyer, or
it's
a sort of financial advisor.
A deputy. It's a really big ask, and usually most people realise that they would be better off having a professional deputy appointed to deal with all of the administration and to ensure that the money is properly spent, properly invested. Because in a larger case where, for instance, you've got lots of care and therapies, there are going to be contracts to be made with people who are providing those services. You can end up employing people, and really, for an ordinary family, that's a lot of admin. It's much better if you can get a professional deputy.
It's quite a big burden, isn't it, on top of the day-to-day management of
you've
family
still got
life.
The person living there, yeah.
We talked a bit about, obviously, cases for children and for people under a mental incapacity. But what about cases where the patient has died? Again, those pose different challenges, don't they?
Yeah.
Both sort of emotionally and practically. And in the cases where a patient has died, then the person who brings the claim would normally be either the person who's appointed under the will as an executor, or if there isn't a will, it's the person would be an administrator, and the law appoints certain individuals for that purpose, so a surviving spouse or a parent or a sibling.
And that person has to bring the claim for anybody who might be claiming, because when somebody dies, it's sort of the case they would have had is part of what can be claimed, but there is also the potential for other people to claim in their own right if they were either receiving financial support from the deceased or were receiving help by way of services. So things the person might have done for them, which can range from looking after grandchildren one day a week while someone goes to work, to helping around the house just in a normal relationship. And so the person bringing the claim has to encompass all of those claims when they bring it.
Again, it's quite a big responsibility, isn't it? But of course, specialist lawyers would be able to advise on what those responsibilities are and how they go about fulfilling those obligations, not only to the deceased person, but also all the family members and dependents and others who may be interested as loved ones, relatives, friends of the individual.
And of course, it's not unusual for there to be differences and fallings out between family members, and sometimes we have to help them navigate those because, for instance, they have to include a claim for a sibling whose child was always looked after, who they may not get on with. So it brings added dimensions as well that you might not have with other claims.
It's tricky, but all of these things can be overcome.
Oh, absolutely. You just have to know to look out for them. And
exactly, it's being aware of the potential pitfalls, isn't it, really, being able to give that full advice. So there's lots of sort of special considerations that need to be taken into account when we're looking at cases being brought on behalf of others. And I think sometimes people can feel a bit daunted by that. But although bringing a claim on behalf of somebody else does cause some additional sort of challenges or can give rise to some additional challenges, there's nothing that can't be overcome, I think, with specialist advice.
Oh, absolutely. And we're used to those challenges and we're used to these sorts of claims, yes.
Absolutely. And so I think that, we're well equipped to deal with those, the problems and the things that arise with this sort of claim. And thanks for helping me answer those questions, Tami.
Thank you.